went to the firehouse is advising them that the male shot the entire family. 137. You're clear.
Where's he at?
Here. He's the shooter still on the porch.
Get him right here, right here. You got him on the porch.
We've asked, that's the last place we've been told.
You show me your hands now! Stand up and walk towards us! Stand up now! Walk towards us! Stand up with your hands up!
We got a visual in the mail. Not showing his hands, not following commands.
Stand up now!
Not showing hands or following commands. His name is Chad Doerman. Chad Doerman.
I know, but we can't.
People need first aid, and he's not complying. And you know he's the shooter. Shoot him.
We gotta find cover first. We ain't no good if we ain't safe ourselves. Hey, no. We need to come from this side where we can see them. Don't take cover behind her. We see them. We're going to approach from this side. We got cover. Right here.
6 covered, 29 and 63 attack that.
We're not right now.
Show us your fucking hands now! Stand up! Stand up! Stand up! Stand up now! Stand up! Stand the fuck up!
EMS, the stage, and air carrier is going to go ahead and fly whenever any units can advise.
Get your hands up here. Cover 21. It's in the air.
Those guys can confirm that there's people that need first aid, and that's the shooter. He's not complying. They need to take care of the
I got it.
victims. They have to shoot him and shoot him.
Man, I ain't trying to hurt nobody. I'm completely sober. Never did drugs a day
63,
in my
we're
life.
21. Get the EMS over here.
Well, I did drugs when I was little, but I don't do drugs now. I'm sober. I'm not trying to fight you.
63.
Get your butt inside. Gatlin, get your butt inside.
We on primary?
Now.
29, we got 3 kids
Main.
down.
3 kids down, 16 feet up.
Gatlin.
63, we're 21.
Knock
Have
it off.
EMS respond over here.
You're clear, they're being advised.
Robert 34, just started mass casualty response.
63, do you want them to respond to the Laurel Lindale address? Where exactly do you need them?
We're right in the front yard. What are you doing, man?
Hey, are you copying all this?
Can I roll over? I ain't gonna hurt you. I ain't gonna hurt
You
nobody.
got anything on you?
No, I ain't got nothing, man. Phone, that's it. I ain't mad. I ain't nothing. Just make sure that dog don't come out. I don't think he'll bite you. Just don't reach for him and try to grab him and pet him.
All right.
He won't bite you.
What's going on, man?
Nothing. Can I stand up? It's kind of uncomfortable.
I'm gonna
I
get
ain't
you
gonna
here
do
in a
nothing. I ain't running
second.
away. You can do whatever you want with me.
Here. You the only one else inside the house?
What?
You the only one else inside the house?
Yeah.
Sit down right here.
My daughter, she ran over to the fire department.
Sit down.
It's my stepdaughter.
Put him in the cage.
State of our This is Chad Doerman, 2023 CRA 1975. This matter is before the court today for purposes of bond hearing. Mr. Kellum, you were here on behalf of Mr. Doerman, Mr. DeCalvi, Mr. Gast on behalf of the state of Ohio. Mr. Count Esteban, go ahead, sir.
Esteban, Your Honor, he is 32 years old. He lives in Richmond, married, is employed. He indicates that his relatives, Gloria Doerman, Todd Frost, and Team Doerman, may act as co-signers for him. At this time, Your Honor, we would submit to the court that a bond of $75,000 would order conditions to be appropriate. Thank you.
Thank you. Mr. Tacalvi.
Judge Mark Jacoby, Claremont County Prosecutor on behalf of the state. At this point, I'm going to let Mr. Gast handle the bond on our behalf. Thank you.
Good morning, Judge.
Good morning.
Judge, we've got law enforcement with us here today. Our office has been involved. Lots of people in our office have been involved with law enforcement throughout yesterday, afternoon, evening, all the way through this morning. And the facts I have for you at this point are as follows. The trauma that this man has inflicted on his family, the community, law enforcement, first responders, and all of the rest of us who have any idea what's going on here is unspeakable. There's been a full admission in this case, Judge. The case is still new. We're still discovering facts. But the evil horror of what we know is impossible to process. In an act of just incomprehensible cruelty, the father that stands before you lined up his 3 young boys, and he executed them in his own home with a rifle. They were ages 3, 4, and 7, Judge. In an act of desperation to save her children, the mother at some point grabbed the gun that father was wielding to attempt to protect them. We know that one of the boys was able to flee into a field near the home. And again, we know from his admission, father hunted that boy down, drug him back to the property, and executed him in front of witnesses. The mother was shot through the hand in her attempt to protect her children. Judge, I asked the court in setting this bond to just begin to imagine their fear. This was the man that every day they woke up looking to for protection, love, guidance in all things. The man they trust more than any other person on earth. The person they rely upon to keep them safe from harm. He was their world, he was their guardian, and he executed them in cold blood. We know that from his admission. By that same admission, Judge, he has committed one of the most monstrous, craven, cowardly acts that will ever be our misfortune to see. To make things even more disturbing, Judge, this was no haphazard act. Again, by his own admission, he planned the events of this day. This did not happen on a whim. He's confessed to what I believe is the worst crime, at least I hope, that I'll see in my lifetime. I hope it's the worst fact pattern that ever comes before this court. Judge, it's important for the court to know in the bond we're going to request today, for the court to understand Claremont County deputies, Monroe Township Fire and EMS, and other first responders bravely respond to the scene where they don't know what's going on. They did not know what they're facing, and they come into a scene that no one can ever be prepared for. No law enforcement training, no training of any kind prepares you for this. It's easy to forget that these are men and women with families, children, feelings, emotions. They're not some automaton performing a delegated function. They're people. They were required to give CPR to gunshot children, 3, 4, and 7-year-old children. They held these boys in their arms, knowing there was nothing they could do to save them. How long do those scars last? What day do you wake up from that and you're healed? How do you unsee such an abomination? Bond factors this court needs to consider today are set forth in Criminal Rule 46, nature and circumstance of the crime charged, and specifically whether the defendant used or had access to a weapon, including the seriousness of the offense. It's the most serious offense that we have on the books, Judge. This is it. You can't commit a more serious offense. So the nature of the crime charge is the worst crime that can be charged. Did he have access to a weapon? Yes, obviously he did. The weight of the evidence against the defendant at this point, Judge, we stand here with a full admission of the defendant. That also goes to the confirmation of the defendant's identity, and witnesses on scene did see at least part of what happened. Next, the court is to consider the likelihood this person would return to court if a bond were issued. Again, this is the most heinous crime with the most severe penalty under the law that we presented to the grand jury. That alone would be a major factor in discouraging a person from availing themselves to this court or any other. And the thought to flee and the likelihood of flight is great in the state's opinion. The danger he poses to the community is a factor that this court can consider, and I think with the facts in front of you, Judge, we can't name a person that poses a greater threat to the community. As his prior record goes, Judge, it is fairly minimal. He was charged with domestic violence in 2010. He is not, to my knowledge, on probation community control. Judge, the facts of this case are hopefully like no other we will ever see. When this case gets indicted in the Court of Common Pleas, I am certain that a no bond hearing will be held, and I would hope that would be granted. But at this point, this juncture, we're going to ask this court to issue a bond we've never asked for before. I'm going to ask for a bond of $20 million. I hope I never need to request such a bond again.
Thank you. Date for preliminary hearing?
The date for the preliminary hearing, Judge, is 6/26.
No objection.
The preliminary hearing will be set for June 26th at 1 p.m. At this point in time, bond's going to be set in the amount of $20 million cash or surety. Anything else at this time, Mr. Gast?
No, Judge.
Mr. Gal? Mr. Kalm, anything further?
Nothing at this time.
All right, thank you.
All rise. Court is in recess.